Okay, so I think we are online now, so we can start finally. So good evening or good afternoon, everybody. First of all, good afternoon to our dear panelists, also to everyone who watching us on YouTube. I'm not sure if anyone is watching us on Zoom, but no, okay, understood. Yeah, so the goal of our webinar today is to celebrate the 10-year anniversary of the Ukrainian Arbitration Association. I remember that when last year, in 2021, we discussed plans for 2022, we had huge plans as to how we could celebrate this anniversary with various conferences, events, and so on and so forth. Unfortunately, these plans did not materialize because of the war, but still we are happy that Ukrainian Arbitration Association has been functioning quite actively and efficiently during the past 10 years. And during the webinar today, we want to discuss what happened on the Ukrainian arbitration market during the past 10 years, what the Ukrainian Arbitration Association did, what it can do further to improve, and so on and so forth. So among the panelists today, we have people who worked hard and continue to work hard to make the Ukrainian Arbitration Association UAA function, and who basically many of the panelists basically created the Ukrainian Arbitration Association 10 years ago. So brief introduction. Today we have Tatiana Stepachuk, the special counsel at Sayenko and the first president of the Ukrainian Arbitration Association. We also have Olena Peripelinska, the current president of the Ukrainian Arbitration Association and the partner at Ukrainian law firm Integritas. We have Mr. Alexander Druk, partner at Sayenko and board member of the UAA. We have Mark Jan Malski, also board member of the UAA and partner at Kaczanski and Partners in Poland. And we have Yaroslav Petrov, former board member of the UAA and partner at Ukrainian law firm Asters. I am Secretary General of the UAA and partner at Integritas Sergei Uvarov, and I will be moderating the discussion today together with Anna Gyar-Sashko, current board member of the UAA. So I believe I have introduced everyone. We can proceed, and I will now give floor to Anna to start the discussion.
Thank you, Sergey. Good evening, good afternoon, everybody. Thank you for joining us today. Let's go back to 2012. As far as I remember, 2012, not many conferences were already in place in many countries. And if I'm not mistaken, the Ukrainian Arbitration Association was one of the first, if not the first, arbitration association in the Eastern Europe. So the first question will be to Tatiana. How did you come up with the idea to create the arbitration association?
Thank you, Anna, and I'm really also happy to see all of you. And you see, it's an interesting feeling when you see faces of people who been with you many years, starting from their very young years, which in effect receive maybe a certain view on international arbitration not because of me, but in a certain extent together with me, and I'm really happy to see them being successful, as well as to see them being engaged in international arbitration so seriously, because the main idea of those who gathered and decided to set this association was understanding that international arbitration is in a certain extent professional destiny. It's something that makes our professional life full, interesting, exciting. It's our professional future. It's our today's life. It's something we want to do. And if we want to do it in the best possible way. And we want to demonstrate to our colleagues that this sphere of professional activity is extremely interesting, important. And on the other hand, it is to be in line, let's say in such words, in line with ethical standards, with professional standards, with international developments and trends, and taking all of these together, and the fact that at that period of time international arbitration began to grow as a professional activity in Ukraine, it was the idea together in order to proceed with these merely as with the professional activity. Well, many years ago, I began to practice international arbitration. It was like the very separate special. It's mostly the former students of Ukrainian Institute KIMO, yes, of International Relations. It was even the faculty at the university. Those who knew about international arbitration from the lecturers, and I could not but mention Professor Vasily Kisil, who is one of those who maybe not being deeply engaged in international arbitration, but being, from my perspective, like a standard of international and in general of the lawyer, of professor. It influenced a lot of minds of young generation at that period of time, and many students of this faculty were engaged. So we gathered together, and Yelena, and also I needed to say that Yaroslav, who helped a lot and assisted in this, Konstantin Likarchuk, who was among the first people engaged in this process. Also, we had at this period Stanislav Tepluk, who also inputted a lot in order to set the rules, to proceed with all this registration, etc. And indeed, we hurry with this launching of this association because it was both domestic and international need to demonstrate to the international community that within Ukraine there is a professional also group, and there is a trend of developing international arbitration. So that was the main idea behind the creation.
I wish I was there. Yaroslav, what do you remember about founding the association?
So I was, hello everyone, and I was not involved into the creation. I joined, I think 1 or 2 years after it was established. So I started helping the association right before the revolution. I remember one of the first meetings we had in the office of Saint Kakharenko, and in the conference room when the association agreement has not been signed, and it was a meeting with Tatiana and Yelena, and we were kind of discussing that what bad consequences it will have for Ukraine, and it was, as you recall, in November. And it was kind of the first meetings when I started discussion my involvement, and after that I worked for the association for several years, and it was very interesting and important experience. And I hope that I managed to make a contribution which was valuable, and there are projects which still continue, and I'm very pleased about this.
Thank you, Yaroslav. The Ukrainian Arbitration Association is about people, is about community. And Ukrainian, as the international arbitration community, and Ukrainian arbitration community evolved a lot in the last 10 years. So the next question will be to our speakers about how they see the evolution of the arbitration community in Ukraine. Markian, would you like to begin?
Well, I think, thank you. In general, the arbitration community in Ukraine, I think, is one of the most united and the most progressive, because I still come from the era where attorneys at law have been always in a hostile environment. We've, back then, some 20 years ago, saw each other as rivals, as competitors. And I remember when one attorney at law called the other one, that meant something bad is going on, that he already arrested the assets of the client of the other, and he just called to inform that now a big war is going on. So now everything changed. So we are much more different, I would say. We became a civilized society of lawyers, and I think you know, the community is definitely something where you can get the best knowledge, where you can get the best information, and where you can meet the best people. It's interesting to see today all the same faces, and I just realized you are all as young as I remember you being. So probably because we see each other so often that we don't catch it like that we change. But you know, if you don't see a person for 10 years, then you would probably think, okay, the person changed, maybe I have as well. But you know, I'm looking today on the screen, and everyone looks the same as 10 years ago, or even more. So what it means we are in constant contact. It means the community is united, and I think that was the goal which was set, to make it united, to make it civilized. I remember Tatiana calling and saying, you know, we have this great initiative, let's do it. And it is true that the Ukrainian Arbitration Association was set up before the Russian Arbitration Association, and so it is indeed one of the first established Central European associations. And you know, if we think about it, that it's already 10 years. If you see a child who is 10 years, that's already a person. And I believe that you know, it is already a great success story. When people ask me, you know, why did you choose arbitration in the first place? I studied arbitration in 2006. Tatiana Slipachuk was my let's say, supervisor of the master thesis, together with Patricia Shaughnessy, and that was back in 2006. And when I studied, everyone told, like, you're going to study arbitration? It's like, it's not a subject. It's not interesting. It's useless. You know, it's, what is this? It's just procedure. It's not law. You should study, you know, securities law or competition law or something like that. And then some years after, people started coming back to me and saying, how have you been so smart back then to choose arbitration? Such a great area. Now each law firm writes on its website, first way, you know, first service is arbitration. No matter it comes with an A, it's always arbitration now is the first. You know, all law firms do arbitration, whatever that means. But in the end of the day, it turned out to be a great area where many people didn't believe in, and they said, well, you know, maybe a Ukrainian Arbitration Association will be, you know, one more association. I was today looking for International Bar Association website. I never remember how it's written, so I always Google it, IBA, and it gives me International Bartenders Association. Now that would be fun to visit, but that's not about it. So I think people just thought, okay, there's going to be an association, just one of them. But I do believe, and if you think about it, probably on the legal market, it is one of the most successful legal associations in a narrower field. So I'm not speaking about the Ukrainian Bar Associations. I'm speaking of a niche legal association. I do believe it's one of the most successful. Thank you.
Thank you, Markian. It reminds me a joke, just I have two flaws, modesty and beauty. So that our association is, but that's true that I think that our association was of the most active. Alexander, I know that you train a lot of young lawyers, coach them for the Wismut lawyer students. How do you see the progress, the evolution in the last 10 years regarding the young generation?
Many thanks, Anna. Indeed, I've seen quite a lot of people on the market who were in the Wismut teams that I coached. And it's been really a great pleasure to observe how the people develop. And this initial push from the Wismut is really something that gives for many people this initial interest. So they really understand what it is, because I believe that MOOCs is something very valuable in teaching. And I think in common law tradition is something that is taught obligatory on every education, is part of education. It's not in civil law countries, but I believe it should be. And in many other MOOCs, it's something that you try and you see how it goes. It could be on many different subjects, some of which you will not try in real life. Like, for example, of course, nowadays, public international law is something on everyone's mind. But generally, it's something that's a bit tricky, and you need to work maybe at the Ministry of Foreign Affairs, be a diplomat to really go into depth. But arbitration is very practical, and the MOOC experience gives you understanding what it is. So the students who try it and actually go through the year of this MOOC, they really understand what it is to actually come to law firm, start working. That's what they do like every day. If you prepare and submit written submissions, you plead your case before arbitrators, and you go through this process. And at the end of the day, this is what you do in real life. And I believe that this MOOC is a great tool to start up and give this interest to people to continue. And for many, it's something that inspires them for many years afterwards. And I believe that indeed it's a good tool. Unfortunately, I think I've seen quite a lot of universities in Ukraine that have and continued this tradition, but due to current situation, we only have, like this year, 3 universities. Of course, I would welcome like every university to continue with this. And in the past, I remember that we had great teams from Donetsk University, great teams from Kharkiv University, from Odessa. In Kiev, we didn't have 2 teams like we have now. We had much more. So there is still a big potential in Ukraine to support the students. And this is also what the Ukrainian Arbitration Station does through the arbitration school, to give the students this also the interest to develop it further.
May I jump in? So actually, just to follow up, I'm also one of those who discovered the world of arbitration in this mood, but not with Alexander because he's younger, so I was not able. I did not have a chance to have his support the student, but still it was really a life-changing experience for me. It was more than 20 years ago, but actually I remember that the initial question was what happened in the last 10 years in arbitration in Ukraine. I would say that if we look broadly, because my legal practice started roughly 20 years ago, and at that time there was no arbitration market in Ukraine whatsoever, so you would not have it was not possible to find a law firm saying that it has a practice of international arbitration, because it was simply not yet that active, as Markian mentioned. It was quite rare that anyone knew a lot about this topic. And it took some years to develop this practice and legal market, etc. And already in 2012, so when the association was created, there was such practice quite active on the market, but the market was quite, I would say, dispersed. So everyone was just complaining. So with regard to court practice, with regard to some probably not really good developments in Ukraine as jurisdiction. But apart from those complaints, nothing was done. So one of the ideas of association was actually to unite the efforts of different market players in order to work for common benefit. Again, the idea of working together as not being hostile to everyone took time as well. And it was quite interesting to watch how the attitude to the association was changing during these 10 years. as in the beginning, probably there were many skeptical views. Probably not everyone understood the value and actually the aims of the association. And I remember some people even asked me, why are you doing that? Why are you just spending your time on that? But after some first results of that common work, I think many Ukrainian arbitration practitioners have realized that together we could do much more for our common benefit and to have our voice heard by the Ukrainian state, by Ukrainian courts, by Ukrainian parliament, and by international community, by the way, as well. So now we have new applications from potential members coming actively without probably that much effort as we had on the first years of the existence of association, and it's quite good to see that that development and to see the growth of arbitration community in Ukraine. Thank you.
Thank you, Elena. I remember 3 or 4 years ago during the Paris Arbitration Week, there were so many arbitration practitioners from Ukraine that some arbitration practitioners from Paris were approaching me to ask, oh, how many arbitration cases do we have in Ukraine? Why there are so many arbitration lawyers? And I was always proud to see that every year there are more and more Ukrainian arbitration practitioners who become known worldwide, not just in Ukraine. Yaroslav, as you're working in arbitration and energy, so how you see the evolvement? If we, for example, now we think about a younger lawyer or a student, would you advise this person to go into arbitration in Ukraine or into energy?
It is quite interesting question, and it is actually difficult to answer because for every person it may play in a different way. So there is no unique kind of scenario how you will develop your career. So in my situation, first I planned to work kind of on arbitration cases, and then when I found my first job related to arbitration, I was offered a split energy and arbitration, and I thought, okay, I will try to combine both of these practices like 50-50. But reality is that it is difficult to be good in both things, and you should focus on one. And for a number of years, I was trying to combine both of these practices, but at some point, I realized that it is very difficult. And right now, I am focused more on energy. It is energy transactional regulatory work, and it became my primary practice area, and arbitration is secondary, and it is mostly focused on energy disputes. And kind of I can tell you that the energy disputes which are focused on specific industry, it is very good niche where you can develop yourself and bring your actual experience from transactions, from projects into the disputes area, and it is also kind of good option. And kind of there is no, as I mentioned, there is no kind of answer which can be given to everyone, and it will work for some of colleagues, younger colleagues. It would be possible to combine both of these areas, but I think the best way to grow in a kind of material law area in a certain industry, in certain practice, and then replicate this experience into the disputes, because as you can see that currently on the market there are many arbitrators and practitioners who have been actually very active for their career in a transactional area, and then later they decided, okay, this experience can be used in in disputes area, and then they become kind of famous arbitrators who actually can bring the value, because they have been working for large international companies, or they have been partners with large firms. So it can play different ways.
Thank you, Yaroslav. But I think you're a good example that you can most likely easily switch your practice areas and be successful. Because sometimes people think that you need to start in arbitration to build your career and to be successful. But eventually when you practice in different areas, you gain more experience, more exposure, and better understanding of business. Tatiana, would you like to add something on the development in the last 10 years?
Yes, I can. And what can I say that this development, not only Ukrainian arbitration, but in principle, it was very serious and very dramatic, maybe altogether, because it was a serious development in the basics of international arbitration, which was mixed with the serious interventions of very emerged circumstances. It's basically even the COVID who played a serious role for the new trends in international arbitration and creation of the virtual hearings as one of the best options we now have for this dispute resolution method. Also, I do believe that such serious changes which took place either in material law, in development of the investment arbitration, in court practice, and the attitude to international arbitration worldwide, to appearance of the new, extremely new disputes for the international arbitration, and which was successfully tackled by this method of dispute resolution, altogether was good for international arbitration and for Ukraine, and Ukrainian legislation, Ukrainian arbitration community, and what is more important for the state, also the development taken in the institutional levels, the development with the ICAC, the International Commercial Arbitration Court, all together tried to follow all these changes. And it's a great pleasure to state that the Ukrainian Arbitration Association was one of the leaders of doing many of these important things during these 10 years.
And I think it will be just a follow-up question to Tatiana, but I also invite everyone to further comment on this. We've just discussed how the community evolved, and obviously it grew in response and developed in response to the development of the arbitration as an industry in Ukraine. So in your view, can you please name a few, 1, 2, or up to 3, the most important developments in arbitration as an industry in Ukraine? So it can be anything like something specifically related to arbitration, or of more general nature, peculiar to Ukraine, or some global trends, but just name a few most important developments in your view.
Thanks, Sergey. I think that maybe the first issue, it's again, it's institutional development and the possibility of the court to change a lot of approaches, being historically criticized or being historically so maybe not so progressive, but the ICAC managed to become open and to hear the arbitration community to accept the practice being internationally acceptable for this type of institutional organizations. And we know that institution plays extremely serious role either in the internal climate, but also for the development of the local professionals. And another one, legislation. I will say, legislation, and this was a very serious battle and a long story. Started when I was with the association, and then continued and persisted, and a lot of work was done. And I think that we are, at least we can be proud and happy for what we did. Finally, definitely there is the room for certain new developments, but it's life. It's always the room, and it means that we are developing, we are living a mechanism and the body. So, and if following the third issue, what I can say, I will say that maybe it's not directly like the sphere of international arbitration, but what Alexander said and what I know is one of the main concerns of International Ukrainian Arbitration Association, it's school. I like this initiative, and it's extremely important because it makes international arbitration wider. It's not like concentrated in Kiev, where the KIMO was to certain extent the place to grow the practitioners. It's now acceptable for the people from different parts of Ukraine to get this knowledge and to receive the best practice reviews from the best international and Ukrainian lawyers. These three things I consider to be extremely important for the last 10 years.
Maybe I will jump in with a few follow-ups.
Sure.
I think, of course, one of the brightest developments was the creation of Ukrainian Arbitration Association, as you understood. Of course, that was bright, and
that was just going without saying that is the top one,
That's
which
the
is
top
just...
No. Let him say. Let him say.
Yes. So I just wanted to emphasize, and then of course, what I remember clearly was when the legislation changes were suggested by the association, when the law was prepared as a draft. You had many outstanding lawyers working on the draft, and then frankly, I believe the law was voted in a rather smooth way. I know it was postponed a few times, but believe me, I've seen other laws being not adopted for tens of years, let's say like that, for decades. And then I think then inclusion of the draft to the civil procedural code was rather revolutionary. So we have articles which are much more narrow, much more precise, much more up-to-date than in many other areas. So I think that was another breakthrough. Then I completely agree with Tatiana about ICAC becoming more open, more transparent, more progressive. And you had more and more young people joining the initiative of ICAC to become, just better. And here I would give record to the administration of ICAC, which was ready to hear criticism. Not everyone wants to be criticized. So I believe they really heard the voices. And of course, I must admit there's much more criticism now than there was, 10 years ago or 15 years ago. And then now I think the end users of arbitration are much more happy. And I think the last thing, we have to be thankful to Ukrainian business, which always tried to go international. Even what happened when Ukrainian business was not able to find enough corporate regulation in Ukraine, then they went outside Ukraine to create SPVs, to have English lawyers governing law of their corporate relationships. They didn't go and fight and shoot themselves with guns. They chose a civilized jurisdiction. So we have to be thankful to them that they actually wanted to go outside. They wanted to be civilized. They wanted to spread out to other countries and do business there. And I think arbitration is also in Ukraine thankful to those businessmen who created this tendency. And then we saw British lawyers coming to Ukraine, to Kiev arbitration days and so on, saying, well, we all have cases from Ukraine, so we are interested, so we will come to the jurisdiction. And of course, I would not like to compare to Russian businessmen, but they of course said, well, it's for us a similar market. So we see what's happening there. We believe that the high net worth individuals will be suing each other in foreign jurisdictions, and Ukrainians are there. So we became an interesting jurisdiction for all of the world, because our businessmen were not afraid and went further, and they chose more developed jurisdictions for that time being. Now we have a much more modern corporate legislation than we used to have. So I mean, that's in the end of the day we should also be thankful for our business, which was not afraid to be international.
Thanks, Mark. Just one follow-up question, and we will then return to top three of the panelists. But you mentioned that was a very interesting observation, that the desire of Ukrainian business to be international was one of the factors that pushed development of the arbitration as an industry in Ukraine. Don't you think that the fact that in many cases Ukrainian businesses choose like arbitration, let's say in London or in Stockholm or in Paris or in New York, with governing law being English law or US law and so on and so forth, doesn't it become the threat to arbitration in Ukraine, in the sense that, okay, it develops arbitration in London, in the US and in Stockholm, but not in Ukraine?
I agree with you. Of course, it will take much more time for the Ukrainian arbitration seated in Ukraine to become better accepted by our own individuals. But in the end of the day, I think it comes also from the habits. They have the habit to go outside for shopping, and they go for forum shopping. So they also shop for a forum somewhere else. And I think it's part of the idea that, well, perhaps something is better. Like the grass is always greener on the other hill, so not on your own hill. So I mean, that's to a certain extent. To a different extent, of course, we cannot argue that that the UK jurisdiction is on an equal development stage as Ukrainian jurisdiction. We exist as a private property country for 30 years. That's basically almost nothing, when you are comparing to a jurisdiction of the UK, where you can find the court order being, I don't know, 500-600 years old, and then everyone refers to it. I mean, we can't say we have it, so it's natural that you would go for the best things. You would want, I don't know, Swiss cheese and Swiss chocolate, whereas you would want, champagne for France. So I mean, everyone has something of its own to share, and then of course, the legal systems of the Anglo-Saxon part of the world is considered to be the best in the world. Is it so or not? It's it can be debated. we can have a separate discussion on this. I've seen many things in my life where I would be a bit amazed why people do something like that. But anyways, so of course it is in a way a threat, but you cannot close up. You cannot say that we prohibit arbitration, everything should go to Ukrainian courts. The current world is being open, and you see on the situation of Russia, which now becomes an isolated, closed country. Well, let's see where it ends in the next years. So the same, you cannot say, well, all disputes shall be decided in Ukraine, and no other recourse should be available to none of the parties. It's impossible. So our goal is to make people trust in arbitration in Ukraine. When they will trust us in the end of the day as arbitrators, as counsel, and where they will feel that the neutrality, independence, and just is there, they would not need to go elsewhere. And in the end of the day, I have seen many transactions now being structured solely in Ukraine and structured by the international law firms. So those who would previously never allow this, they would never recommend the client to conclude any shareholder agreements whatsoever under Ukrainian law. Since the new law was adopted, they are the ones who accept this. So it in the end of the day, it's all possible. And then, in the word impossible is impossible. So everything's possible, but it has to be on a certain level. And when we achieve this level, I'm sure everything will be fine. But, still, the top of the world also gives the majority of the disputes to be settled in Switzerland, in ICC in France, and so on. It's a certain standard. Of course, it's much more expensive, but you aim for the best. And I see no big threats. I think the arbitrations in Ukraine are growing, and I think more and more people are liking what they obtain as a result. So I believe we should remain open, because you have to be open in order to also get from others, the best results they had.
Thanks, Mark-Jan. So now, yeah, Olena, please.
Yeah, I would like to jump in just to echo what Mark-Jan have just said. Of course, 10 years period for Ukrainian arbitration industry is a huge, because the basis for this industry was created roughly 30 years ago with the solution of the USSR. As you remember, during the Soviet time, it was only arbitration was concentrated in Moscow. There were no private property. There were no normal commercial activity in the sense we all know it. So just only when Ukraine got its independence, it was the basis. We had the basis for developing arbitration industry. We had the law on foreign economic activity, or about international commerce, so to say, providing some basic rules for that. And of course, when Ukraine adopted ancestral model law, that was one of the huge development to create in the basis of Ukrainian legislation, arbitration legislation, and it was adopted almost without any deviations from the initial version of the ancestral model law. And at the same time, Ukraine adopted some changes to its current legislation to that law on foreign economic activity, providing that the disputes under this international contracts could be submitted to arbitration as well, which was really important move. Changes to civil procedure legislation with regard to enforcement of arbitral awards, etc. So I think that was a huge step back then. Then there was also a huge important milestone, the Supreme Court resolution of 1999, number 12. I understand that it's an old one, but it still contains some basic rules explaining why Ukrainian court practice developed in a way it developed, because it actually said that, okay, you can now go to the merits. You should now amend arbitration award in any way. And it also provided for the very narrow definition of public policy. I think that was simply like ground-changing rule limiting the court intervention and limiting the use of the court by the Ukrainian courts of this very popular ground for refusing enforcement of arbitral awards or for setting aside of arbitral awards. And we also have quite exotic but still existing rule on foreign currency regulation, contributing to a certain extent to the development of arbitration industry. And I would probably explain this to our foreign colleagues if they are looking, they're watching our webinar. So for a long period of time, Ukraine had very strict foreign currency regulation, meaning that the state controls whether Ukrainian buyers receive the goods they have paid for, or Ukrainian sellers receive the payment for the goods they delivered abroad. And this, in case they have not done that during a certain period of time, Ukrainian tax authority could charge penalty. In order to stop this penalty accrual, the Ukrainian companies should go either to the court or to arbitration and file a lawsuit against the other party who has not paid or has not delivered the goods. And as the law and this regulation specifically mentioned arbitration, ICAC, Maritime Arbitration Commission at the Ukrainian Chamber of Commerce and Industry, this really contributed to the parties understanding that they could go to arbitration rather than to a foreign court. And they have actively included arbitration clauses in their international contracts. And they, once they have a problem with their contractual partners, they go to arbitration without any hesitations. And I would say that this despite the very strange nature of this rule, it still had its benefit in terms of development of arbitration industry and of parties understanding that the best choice of their dispute resolution clause would be arbitration. And they should pay attention to that, not to have foreign court, for instance, there. I will stop here with my historical overview.
Thanks,
And I
Elena.
will briefly add also on the
Sure.
big developments, and I agree with my colleagues that the legislation is the one that we can really see it. And as I do both cross-border litigation and arbitration, I can tell that if you have an arbitration case, for example, arbitral award, you receive the broad and you come to it to Ukrainian court to enforce, you now have much better chances for a streamlined, fast, efficient, and reliable procedure to get it enforced and actually receive and collect your money than if you have a foreign court judgment. We as Arbitration Association, of course, worked on the improvement of arbitration environment, and the draft law that we prepared, it concentrated on improving arbitration. But the amendments that were introduced, they were put into the section of the Civil Procedure Code dealing with both foreign court judgments and arbitral awards. But of course, the amendments that were introduced, they only touched on this arbitration part. And you can see the difference. So first of all, on the procedure itself, the new rule is that there is a single court in Ukraine dealing with recognition enforcement. It's Kyiv Court of Appeal, and it allowed to really simplify the procedure, because in the past you have to go to local district court in any region in Ukraine. You can end up anywhere, and the judge could be dealing in parallel with your arbitration case with some I don't know, like labor disputes, some criminal cases, and some of the judges didn't even know what arbitration was, and they were learning as they go with the enforcement case. So this is still the practice for enforcement of foreign court judgments. You end up in the local court at the very first level, and then you go up through the ladder in the court system. That's not the case with arbitration. You immediately go to one court in Ukraine, it's Kyiv Court of Appeal, and you have just one level to appeal to Supreme Court. This is really a huge advantage, and it really helps if you have an arbitral award as compared to court judgment. And it also goes to many other aspects of this whole procedure. In particular, Olena mentioned the currency control regulations. They are not only with respect to this payments by buyers and sellers, they are also enshrined in various procedural rules. Like, for example, if you come to Ukraine with a court judgment, when the court actually grants you this recognition enforcement order, it will automatically convert your US dollar or euro award into Ukrainian hryvnia, Ukrainian currency. And this is it. Like, you may have a situation when the currency devalues when you enforce, and by the time you get your hands on the money, it's much less than you expected. It's not the case anymore for arbitration. You can get recognition directly in the foreign currency. And these are developments that really are quite obvious and simple, and they really help in real life to businesses. So it's good that we have it, and we have achieved it in arbitration. Let's hope that the litigation part also catches up. But this is indeed that is something that you can talk to many of your colleagues around the world, and some of them are quite amazed that there are these developments, there are these special procedures, and there is also like many things that appeared in Ukraine, including the interim measures that you can get now in support of your arbitration, not only in Ukraine, but anywhere in the world. This is also a part of this new reform. So I would say that the arbitration scene has seen this huge development and great many tools that can be used and to the benefit of the parties.
Thanks, Alexander. And basically, as we move to the courts, I think let's discuss more specifically how, in your view, the court practice related to arbitration evolved during the past 10 years? In a sense, whether the courts became more sophisticated in arbitration, whether they know more now about arbitration, whether they have become more arbitration friendly, or maybe they were always arbitration friendly and they still remain arbitration friendly. So I would invite Yaroslav and Alexander to discuss this, well, to provide their views as counsel. And let's say Mark-Jan, Olena, and Tatiana provide their views as arbitrators here in disputes in Ukraine. So in your view, did the court practice change? So maybe Yaroslav.
So for me, it would be quite difficult to comment on this because I have not been following the court practice for several of last years, but I think this question can be actually redirected to you, because I remember that you have done a very good analysis of the court practice of Ukrainian courts for a certain period of time, and you have done quite important informational graphs. What are the trends and what is happening? So I think you're better positioned to comment on this than me. But of course, there have been changes in the practice, and it is due to our changes to legislation, which we have managed to lobby. So yeah, it has been improving recently.
Indeed, we do have that empirical data, but before I discuss it, let's hear the views of our panelists as to what their impression is. So, Alexander.
Yeah, I agree that there was a change, and I think for the better. This basically boils down to this simplified structure of the courts that deal on a day-to-day basis with the application, both for setting aside and for recognition enforcement. And I think the judges and the courts that constantly deal with that, they develop their procedures, practice, and they get more accustomed with the arbitration. And I have not seen, like in the Court of Appeal or in the Supreme Court, the hearings, judges who were completely unaware of what it is, and they just start learning it and asking questions that based on question you understand that they don't understand some fundamentals. All the judges now understand it, and there are very good judges who came after the recent procedural reform to the courts, who were selected in the new qualification exams. They came both from business, from academic circles, and they're very knowledgeable. And we have quite a lot of very good decisions by the Supreme Court in particular. Some of them address, for example, this point that Elena mentioned about public policy. I believe that there was summary by the judges of the Supreme Court where they characterized this public policy as a last argument of a defendant who doesn't have anything other to say, and that these courts should be critical whenever somebody raises this point. So I think the judges have become not only more academically more prepared, but more practical in a way that they see through some of these tactics. They understand what it is that parties argue, want to achieve. And of course, there were, I could probably name a couple of important Supreme Court decisions that happened during the last period. And probably one of them is the approach to sovereign immunity, which currently is something that is on everyone's mind in respect to the claims against Russian Federation. But actually, the Supreme Court looked at that issue already in 2018-19 in the context of enforcement of an arbitral award, not just a claim against Russia. It was an arbitral award also against Russia, but the court for the first time said that Ukraine is bound by the terms of the UN 2004 Convention on jurisdictional immunities of the state and their property, even though Ukraine has neither signed nor ratified this convention. And that was like a breakthrough because, well, that's quite a profound change of attitude and approach. So once you have it, then you understand that you can look into further positions, how to develop your arguments when you deal with disputes involving the state. And of course, public policy is something that is constantly being developed, and also in the practice of the Supreme Court. And I think the recent couple of years were the focal point when the court changed some of its long-standing approaches, in particular in light of the sanctions that were imposed by Ukraine and other countries. And I think the approach is still being finalized, whether you can or cannot recognize and enforce an award where you have somebody who is under sanctions. These are probably like big points that were raised by Supreme Courts. Of course, there are many other approaches and decisions, and hopefully my colleagues could also raise some of them.
You're muted.
You're on mute, Sergey.
Sorry, I muted before I started to talk. So thanks, Alexander. Tatiana, in your view, how did the court practice change?
Dramatically. Yeah, indeed, dramatically. If we return back to what we have when we started, when I still was with the ICAC as Secretary General, maybe it was one of the most hard tasks to make the judges not only like to turn them to international arbitration, to make them understanding it, to explain to them specific things. You know that it's extremely impossible to explain to judge something. They know everything, and the judge itself, it's already the reason to be skeptical to all what you are going to say. And it was a very serious work. And you know, there is such the school for judges, and ICAC did a lot and lectured, and we explained very simple things. The most important was for all these years that we always have a good audience. They listen, and it is important. And now we have the results of that. And Alexander mentioned all the reasons why we have now more experienced judges and better practice. But unfortunately, I can say that it's like a vulnerable process, and the judges and in practice influenced by a lot of different things, and the political disturbance and economical, and sometimes even it looks that the decisions are based on some deep considerations that nobody can accept from this situation. When they are going deeper and deeper in the question, there is no necessity to go so deeply, and it makes them to make a mistake, unfortunately. And maybe one of the recent cases connected with the setting aside of the ICAC award, it demonstrates that sometimes judges really, they being maybe guided by good motives, they did bad practice, unfortunately. But in principle, indeed, it's dramatically changed. We have now more experience, more internationally minded, English-speaking judges who can read the original documents, who can cooperate with their colleagues and discuss the same language and the same language, the same problems. That is important. Markia, maybe Yelena, you know that some details in Canada, but it's really progressive development.
I can add a few words. You know, first of all, the best thing, we haven't seen any ridiculous decision in the last couple of years. So, I mean, that's a minimum requirement. No ridiculous decisions that, you know, simply blow out your head. Reading that, you know, public policy is interest calculation in an award or something like that. You don't see this anymore, and it is a good thing. And so the level of decisions has increased, and not without the assistance of everyone here. Why? Because when you write an article, not your potential clients read those articles. Those articles are also read by judges. And those, we don't think about this so much. We think, okay, we write the articles for the community, we write the articles to be seen on the arbitration society level. But in the end of the day, judges also Google. And judges enter, recognition and enforcement of foreign arbitral awards in Ukraine. And then they see works of all of you, all of us, and they read the same things. And they think, okay, those 5 authors of those articles wrote, close to the same thing. So I should, stick to the mainstream, and this is how it works. Okay, so it works. So without even knowing this, we contribute to the judges who in the end of the day, by simply reading, the legal articles available in Ukrainian, are now able to understand better what is arbitration. And that's our passive contribution. And our active contribution is, of course, sometimes the amicus curiae, which we write. And that is also quite brave, and that is also quite interesting. So I believe also for the judges, this may come up as a surprise. You review the case, and then you get this out of nowhere a thought of association. You go into Google, who are those people, and then you see those are serious people, and you start thinking, okay, I should read their thoughts, and that's the active part. So we both cooperate with courts in passive and active parts. And in general, concluding, I would say that the fact that only few awards have been set aside in the last 3, 4, 5 years, I think that's a big applause to the level of ICAC and to the level of judges as well. So I think now the cooperation between the arbitration community and state court judges is on the highest level that it has ever been. And I think we really have a great development here, and we can really say that this was achieved really in the last years.
So to conclude the discussion on the courts and then the court practice, I will now pass the floor to Elena, but I will ask you, Elena, to address it from a slightly different perspective. As Yaroslav mentioned, we did the survey of the court practice, which basically showed that in terms of the end result, so the very, very, very final judgment, Ukrainian courts turned out to be always pro arbitration. So it could take, let's say, 5 or 8 years to get that final judgment, but still, in terms of statistics, the courts were always arbitration, and so they remain more or less the same level of arbitration now, in terms of how many arbitration awards are not recognized and how many the arbitration awards are set aside by the Ukrainian courts. And on the other side, we also had already comments that okay, we do not see anymore the ridiculous decisions which we could see like 10 years ago, for example. But at the same time, we still do have quite many, I would say, judgments which arbitration community criticizes as being.
He's frozen.
Yes. But Elena, you got the question, right?
Okay, while we were waiting for Sergei, I will make a brief historical introduction. Actually, I started my legal practice in 2003, so it was before current civil procedure code was adopted. So I actually had the opportunity to see like pre-existing era of and legal regime for recognition and enforcement of arbitral awards under Soviet legislation, because we have Soviet civil procedure code and we had a kind of instruction from Soviet time how to deal with it. And we had a court. Okay.
Anna, this is why having
no,
two moderators is
I
always
see
better
it's
than
a
one.
problem.
No.
It's a problem with the electricity. I see that. So I hope our translation in YouTube is still ongoing. So I will proceed. I hope they will come back to
It's
us.
okay. We're online.
Yeah, and actually in like Soviet era legislation, there was a separate law governing or regulating enforcement of foreign court judgments and arbitral award. And then suddenly in 2005, we had a new civil procedure court, and it ruined the pre-existing system. When there were two court instances, it created 3, even 4 court instances for arbitration-related matters, and it initially had not regulated some issues like setting aside. It was just out of law. It was not regulated at all for several years. And indeed, it was a chaos when we had some very, very low-level courts dealing with arbitration matters during many years after the period when we had only courts of appeal and the Supreme Court. And actually, that was the reason why association lobbied the changes. So we wanted the previous system back when 2 court instances were involved in all arbitration-related matters, and it was more efficient. And Arbitration Association actively offered this solution to Ukrainian Parliament, and as together with the package of all procedural rules, etc., etc. And actually, in 2017, when the big judicial reform was adopted, these changes were added to the Civil Procedure Code. And I would say roughly 80% of the chapter dealing with enforcement of arbitral award matters was the product of Ukrainian Arbitration Association. Sergey, you are back, so please finalize your question. I was diverting attention from your absence.
Yeah, sorry. We had, I think, internet shut down in the office for a couple of minutes. I'm sorry. Well, first I need to say that Yaroslav is going to leave us now. And I would like to say thanks to Yaroslav for joining us. So it was a pleasure to have you on this. And as regards my question, I'm not sure where I stopped. But the point was, the main point was that in terms of statistics, the practice of Ukrainian courts was always relatively pro-arbitration. And it remained the same now. At the same time, we have heard today that the judges became more professional, the courts became more sophisticated, and so on and so forth. And generally, the practice became dramatically better. So why do we still face the judgments which are, in the view of the arbitration community, wrong and not pro-arbitration? Maybe they are not ridiculous, but still they are criticized by the arbitration community. Why is that, and how we can deal with that?
I have a couple of explanations. So first, the judges did not come up with the reasoning they alone. So it was, we should look a step back. It was one of the counsel offering some reasoning which the arbitration community sees as not the right one. I don't know whether there is an effective way how to deal with that, but probably the council, so sooner or later, we will have the situation like I remember one of the cases we had with Tatiana many years ago in Switzerland, when we asked for potential setting aside proceeding, and local lawyers simply refused. So they did not believe in that in the success of that exercise, and it was not about money; it was a professional ethics. and duty to the court, etc., etc. So I hope our arbitration community will achieve the same level, and we will not have such reasonings offered to the state courts. It might be, of course, some just an error. So we are all humans, and that is why some situation it might be too complicated arbitration issues for a particular judge or a panel. But what Ukrainian Arbitration Association is doing is actually helping to educate, to give more information about international court practice. And Markian already mentioned about amicus curiae briefs, and this is one of the way how Arbitration Association is trying to help without taking the side of one of the party, just giving the courts information about foreign regulation or court practice on a particular issue. And even if in a particular case our amicus curiae brief is not successful, I remember one case, this was LG case, when we filed one of our first briefs, and the award was set aside in the end, and that decision was criticized by the arbitration community. You could think that, okay, it was not a successful experience for Ukrainian Arbitration Association, but about a year later, in one of the conference, I met a Ukrainian attorney who told me that he submitted our amicus curiae brief from LG cases in his case. And in that case, the Supreme Court decided not to set aside the arbitral award. And one of the reasoning used by the Supreme Court, without clear reference to this amicus curiae brief, was very similar to the reasoning of a Swiss Supreme Court in a case we described in that amicus. It was a Brazilian football player case. And it was so good that Ukrainian court used the same reasoning as the Swiss Supreme Court did, and made it very elegantly. And it's not about like referring to Ukrainian Arbitration Association amicus curiae brief. What is interesting in the end result, and is now the part of Ukrainian jurisprudence helping other parties in other setting aside proceedings, because it's a Supreme Court decision. So in that sense, so it had its own life, and as I understand, it was used in some other cases as well. And I think with Ukrainian Arbitration Association, we could be proud of the success of such results of our work. And we still should monitor the court practice and offer our assistance on other issues when we see it is important. So as we have new judges, we have a new council, we should probably openly discuss some strange cases, probably discuss it with arbitration community in order to deal with the first theory I've mentioned here about the conduct of legal counsel, about because it's very dangerous to use some legal arguments which are fundamentally wrong, and to have then a judgment reflecting the wrong argument, because in the end of the day, that will come back to you in another case. So it's like karma. So yes, it will find you. And this is dangerous for the entire arbitration community, because once it is said by the Supreme Court, it would be very difficult to change the position, because the Supreme Court's legal position is has special status and importance. And yes, so if we could easily talk with legal practitioners, it's not so easy to talk with the judges. So, and we could indeed write something, discuss it on the conference, and I should give credit to Markian, who wrote not articles, but books on arbitration, which I am sure are in the library of some Ukrainian judges. So Markian, thank you very much for that. Yeah. And the first one about arbitration agreement as well. And so I think that's really important. There are not so many books on the topic in Ukrainian. It's good to have them available, and I assume you even could have sent them the copies to potential important audience. And this could change everything, of course. And when we are educating young generation, we should also educate them in a sense that they should behave ethically and they should think more globally about their conduct before the court or arbitral tribunal. Thank you.
Thank you, Elena. The truth that education is very important exchange of opinions, and I also noticed that last year's arbitration conferences in Ukraine were attended also by judges. So judges are also showing interest, and that Ukrainian Arbitration Association already organized educational events for the judges and planning to organize them in the future. Now, as we discuss karma in arbitration, let's turn to a little bit another perspective, to your personal way in the arbitration, your career, or the involvement of your practice. One of the questions that I would like you to address is whether you have noticed whether it became a trend for Ukrainian law firms to be lead counsel or to be an only counsel in big arbitration cases, in important cases, because it's just like 10 years ago, even as far as I remember, many law firms, they had arbitration and litigation practice. Now we see that many law firms have arbitration and independent practice. So what are novelties in the last 10 years? Alexander, what is your experience?
Yeah, my experience is that indeed Ukrainian law firms very frequently appear as lead counsel in various cases, including big ones. And I think what's good about Ukrainian law firms is that they're very flexible, and we also have very good experience of co-counseling on different matters where we split some of the responsibilities and tasks between different counsel, and it usually happens when you have a foreign law. So as Mark Jan mentioned, it's not always that you have Ukrainian law, and if you have like English law, maybe Cypriot law, maybe Dutch law, Swiss law, you need also professional assistance from relevant counsel in the relevant jurisdiction, because, well, you can't really fully cover some of the issues that are could be very intricate under foreign law. So we had quite many cases where we have co-counseled with counsel in the relevant jurisdiction, and we split responsibilities in different manners, like the relevant counsel handles the local law issues, and we, for example, handle general supervision of the project, the dealing with facts, witnesses, and the same for the hearing. There could be division, what each counsel does, and responsibility for various tasks in the course of the proceedings. And we have seen indeed that over the past years, many law firms had just dispute resolution practice. Now, in many cases, it's purely arbitration, where it could be combined with cross-border litigation, but the domestic litigation is normally a separate practice, and they deal exclusively with courts, with local disputes. And you really need to have more and more specialization in arbitration matters to keep on the same level. Of course, you may have as your opponent any law firm in the world, so you're not competing on national level, you're competing on international level. And of course, you need to keep it up to be in position to represent properly the client.
Thank you, Alexander. Tatiana, as you work with Alexander at the same firm, but you have had the different also exposure in arbitration, what is your experience?
If I speak about the last years, my experience is extremely different, including arbitration and all the spheres. But from maybe even behind the creation of these Ukrainian Arbitration Association was the idea that namely Ukrainian councils should be the lead of the procedures connected with the Ukraine as the jurisdiction in Ukrainian courts representing Ukraine in investment arbitration cases. And it's nice to have now already these cases where namely the Ukrainian company is the lead counsel to Ukraine, to the state. So it's extremely important. And what the result of this we see on different ratings on this all international scoring, which appears in Legal 500 and in Chambers and the best lawyers, and we see the Ukrainian names among the leaders, and that was one of the ideas, the aims, the goals of Ukrainian Arbitration Association, and that is done. So it's not the end, but it is done already, and it's a great thing because now we have the Ukrainian representatives of the boards of different institutions, etc. It's not the one person, but the only which is just appears. It's the plenty of people being engaged in different activities and being recognized. That is important. And what it means is that they return back to Ukraine, to Ukrainian practice with this international experience. It's a process. It's the mutual process because we all in our cooperation, in our common work, in conversations and communication, we exchange opinions. We have this international knowledge to be kept. And another thing which I believe is important, that this process also brings to Ukraine, to the Ukrainian institutions, the necessary level of knowledge. And also Yelena mentioned, and somebody else, I don't remember, but regarding the articles, yes, it's extremely important. We need to return back and we need to share this knowledge and the experience with others. It's extremely important because only on this basis we can create the field which is administered in the necessary professional level.
Thank you, Tatiana. Markian, if not mistaken, you were recently appointed to the board of Stockholm.
Mm-hmm.
In Stockholm. Congratulations.
Thank you.
So what about your experience in recent years in your practice?
Mm-hmm. Well, thanks God I have already lived some time on this planet, so I can compare decades already. So I remember 20 years ago, as a Ukrainian lawyer in Freshfields, I was somehow unique. I was probably one of the few Ukrainians that at that time made it to Freshfields, and then basically, such companies, such international law firms would always hire a Ukrainian law firm to do, for 30-40% of the case, 25-35% of the case. If we look 10 years ago, foreign law firms would be referring still to Ukrainian law firms, but they would be, willing the Ukrainian firm to be something between 15 and 20%. And now basically each international law firm has a Ukrainian specialized arbitration lawyer in-house. And the amount of work referred to Ukrainian law firms is now between 5 to 10% in a case, and sometimes it only refers to expert opinions on Ukrainian law matters. Now, this is just the development as it is. I don't judge it. I don't say that, it's good or bad. Of course, for Ukrainian law firms, it's bad because they have lost a part of the job. For international law firms, they have expertise inside. For Ukrainian lawyers abroad, this is good. They can develop in other jurisdictions, but that's a clear change I see. What Tatiana has mentioned about the fact that Ukrainian law firms are becoming, or are already for some time, lead counsels in the cases, this is indeed a wow. We are on an international level, and again, I would thank Ukrainian business who who has nothing against, suing a foreign company. I remember some 12 years ago, we had a case where the Ukrainian company was a claimant against a Finnish company in Stockholm. And everyone was like, wow, you're really brave. You're bringing this claim. Do you believe you're going to win it? And then we won the claim. And, and it was like, isn't that what about arbitration is? It's about being fair. So, we had a fair situation. We won the case and we were the lead counsel. Yes. And we took an expert opinion on Swedish or Finnish law from a Scandinavian firm. And we pleaded the case ourselves, two young guys coming to Stockholm, and we pleaded the case and we won. I mean, maybe 20 years ago, that would be much more uncommon. But when you see the young generations, they speak English, they take part in Vismuts, they have wonderful resumes, the better than we had at our time. I'm now teaching at the Warsaw University, so I am telling students that they should go to arbitration, and there are much more people involved in arbitration than 10 or 20 years ago. And, in the end of the day, I think it's good. And what we should really aim for is really the ethics of maybe we should even refrain from talking about guerrilla tactics and things like that, because as soon as we talk about them, we plant a seed in the head of a certain person. You think, oh, guerrilla tactics, I should use that, right? No, and that's the whole point. No, you should not. So, I mean, the practice is changing, and I do believe that Ukrainian law firms will be much more active in terms of being lead counsel, again, also in investment treaty cases. And that's a wonderful development. I think we now have what to share. We have been able to create a solid ground for the future. So in terms of arbitration, I'm very positive for what has been done, and I think that's the proper words to say for the 10-year celebration of the association.
Thank you, Mark-Jan. Very optimistic. Now, that's true that from my perspective, working in Paris, I see that in the last 5-6 years, like each year, there is an increase in students, young practitioners coming to Paris. So it's usually like before London was open to foreign practitioners, now it's Paris. Olena, and what about your perspective, personal or your practice?
If we talk about Ukrainian council as lead council, just a few points. Indeed, we see, if some years ago it was quite rare for Ukrainian market, now it's more and more frequent, and I have seen that both as a counsel in international cases and as arbitrator. Just in ICC, in LCA, I have seen Ukrainian counsel as lead counsel pleading the case, and it's really great that more and more law firms are doing that, and are doing that on a proper level. And I think this is important for them, because the arbitral institution will notice them for further potential arbitrators appointments. And I also see more and more Ukrainian arbitrators appointed. I would like to give a credit probably to the Ukrainian Arbitration Association, who in the beginning of the war launched this media campaign, appoint Ukrainian arbitrator. But even before that, so it was, of course, not the start, but so we try to contribute to the number of appointments of Ukrainian arbitrators abroad. And this is also quite great, because they are obtaining experience and use it then as counsel, as experts, etc. So it's quite enriching in any case. And we see more and more big cases involving Ukrainian elements, and I think this is also important for the market in general. And this is one of the reasons why UK lawyers are interested in Ukrainian markets as well, in arbitration. I think that it's one more moment which is interesting. So during the war, many Ukrainian arbitration practitioners went for secondment in international law firms, and they're spending their time there working on very big international cases. They would have probably not been able to work on being in Ukraine. And I hope that after Ukraine wins, they will come back enriched with that experience, and will be able actually to even to have a better level of council work as lead counsel on behalf of Ukrainian law firms. So I think this would be also quite an important element and contribution to the development of Ukrainian arbitration practitioners community.
Thank you, Elena. And it's not only the secondments, that now different universities provide different scholarship for students. So now most students and young practitioners will have opportunities to study abroad. Arbitration is very often about being serious practitioner, spending late nights, or like traveling a lot before COVID. But also a part of our life is a good laugh, especially when you're tired. Maybe laugh is the only thing that keeps you awake. So now I would like you to share fun stories in your practice, something that was something that you can share, and you're sure not then to be disqualified as an arbitrator. No, I'm joking, but something that a fun that you had, or I don't know, you tried to wake up an arbitrator who was sleeping. Markian, what will be your story?
Now, once you mentioned not to tell something which may disqualify you, I really lost the majority of my fun stories. No, but jokes aside, you know, it's you know, there's much to remember, nothing to tell. I must frankly tell you, but you know, somehow I was always facing some extraordinary situations, and you know, the wartime, of course, is different. You know, for the wartime, I happened to be in Poland with my family, and I realized that, you know, I had one pair of shoes with me, for example, and there was an interesting thought that, you know, whatever you were constructing and building before the war just stopped mattering anymore. And then, you know, I think the story I will tell you is how I now saw, for example, the ratings of law firms in Ukraine. You know, it's like it just didn't matter anymore, and it's like still some ratings were trying to do the ratings into rate, and many lawyers just said, you know, just not now. You know, it's not like the time to be speaking about the same things. So the things really changed, and then I think also did we. So I think we are on a certain break in terms of this fierceful competition and fighting for the clients and so on. I think the war has changed our mindsets to a greater extent, and we realize that we are just becoming different, and we are starting to value things that we never valued, and probably it's also a time to sit back a little bit and you know, rethink many things you have done. For me personally, you know, the war has brought an even more necessity somehow to be involved in the development of younger generations. Surprisingly, I went to the Warsaw University, I think on the first weeks of the war, and said I want to teach international arbitration, you know, and the Warsaw University says that, wow, we really don't have a lecturer for that right now, and the person who is teaching arbitration right now is fully booked with other subjects, so she's going to be just happy to give it to you. And so somehow that the war for me has brought the necessity to help younger people. I don't know, that's an interesting observation rather than you know, than a war or a fun story, but probably a war story that I'll be now more involved in helping others.
Thank you, Markian. I think it's also a karma story in a good way, because it's you will not hesitate and think, should I go, should I wait? You went, and it was like different coincidence, so you could start teaching. Tatiana, any fun stories? Markian's, it was mostly like philosophical story.
Sorry, you know.
Probably in this issue, I also will join Markian's mood, because you see, frankly speaking, all these fun stories, they remain in the mind, but they are like very deeply inside of you, because your actual day-to-day mood is very, very different. And going back to my life, I always try to set something. I like when there is something which you can left behind you. And I'm really happy that within my life was there were very different periods, and the ECAC and setting the international arbitration practice when I joined Vasiliki Sealand Partners, and opening the international practice regarding the WTO organization. And just for me, it was something that I can left for those who can take and move forward, because it's the only reasonable thing. And now when we face this war, and now when I have time to communicate and use my position being for a long period just traveling to Ukraine but being abroad, and I understand that there is no any former president to apply for the situation we have. We need to gather and to create the response to legal response to these aggressions. And we need to explain each day, each time, each moment when we communicate to our colleagues abroad that this is unfortunate, unique situation, and this unfortunate, unique situation, which is so painful, so bloody, so unjustful, so many negative words we can use, so many tears, so many tragedies, so dramatic that it could not be understandable sometimes how it can happen in our world now. And the response should be so unique, so unprecedented, so adequate that never before we can look back to different cases, to different tribunals, to different situations. We need to take everything workable, everything that can be used. But it's not the situation when we say, okay, we will do like in this case or in that case, different tribunals established, Kuwait situation, Sierra Leone, other. They were different from what we have now, because now it's something which is going beyond the basic principles of human existence. And so maybe here what really Makian is in depth, right? That we need to throw away all these, in Russian there is very nice word, tarakani, mышиные бега, you can name it in any other words. The most important issue for us as professionals to now to contribute to this, to find this solution, to be persistent in opening the door, which sometimes our colleagues, they really do not want to open because they are scared. And I can understand why, because we are all scared as well in depths of our souls, but we need to respond. Maybe I'm sorry that I'm in this perspective speaking about this, but for me, it's really, sometimes I could not really understand how you spend your day, because you spend it, and I do believe that you understand me, you spend it in a very specific mood, which is now in all the souls of all Ukrainian people. And that's all. Sorry.
Thank you, Tatiana. So we continue with the philosophy, and the truth that starting from the first day, and just I don't want to cry, not online, but what touched me the most, and I think many of us, that from the first day of the war, how we felt united, and how really we wanted to do things together, to help each other, and a response from international community as well, that we did not left alone with the war,
Yes.
but what is continue, and the efforts of the Ukrainian Arbitration Association, the efforts of us as lawyers, and the efforts of us as just ordinary Ukrainians, that we fight, everybody fight as he, she can, and that one day Ukraine, we will win, and it will make us stronger. But it's true that there are so many things that seem unreal in 2022. Okay, just Olena, I hope that you have a fun story.
So I will first start with serious issues. So I think that just to end up or sum up the topic of the war. So of course this year has changed our lives, has changed our practice and our mental condition, and I think we have demonstrated to the world as the Ukrainian people and as arbitration practitioners, our resilience here and our capability of working in very, very unusual and difficult conditions and do it professionally. And I think this is important for the arbitration community to continue working, to have their cases as arbitrators, as counsel, as expert. And it was actually not easy to persuade on the very beginning of the war that we are still capable of doing that, because the assumption of many foreigners is, okay, is it possible to work in Ukraine at all? I mean, no, as a perception, and it took some time to persuade them that yes, it is possible. Yes, it is possible with some challenges, like electricity cut, like air radar sirens, etc., but still possible. We have our hearing. So just last week, Sergei had a hearing in ICAC. I had a hearings in 2 Swiss cases, all from Ukraine. And yes, I had some issues with electricity, but it was like very minor one, and it was easily solved. So in any case, the point is that as arbitration practitioners, I think we have now a unique experience of doing that and sending message that we are capable of doing that to the world. And as arbitration practitioners, we are more suited than anyone else to help Ukraine with international law issues, with public international law issues, with issue we all have with this reparations, accountability of Russian Federation at all. And now Ukraine has very uneasy task to change the international system, which was created after the Second World War. And as an arbitration community, we also should contribute and should help Ukraine with that very uneasy task. And as Ukrainian Arbitration Association, so on local level, we have provided our comments to draft laws regarding sovereign immunity and issues like that. And on different forums, we do discuss this issue and trying to persuade our foreign colleagues to change, actually, the system, to change attitude to the existing issues. And I hope that in the end of the day, we will change it altogether. And I see that as a task, one of the common goal of Ukrainian arbitration practitioners to help that happen. And one of the, probably just to relax a bit, it's difficult to find as micro some case or story fitting to our format, but I will tell one. It's not funny, it's more like a life story related to arbitration, but for me personally, it was quite important. When I had as arbitrator, my first case in ICAC, so I'll have already some experience arbitrating in other institutions, but with ICAC, it was my first case, and I was a sole arbitrator in that case. So actually I have several cases in parallel, but one of the case which was most important, so I drafted the award. It was not like just for one in favor, just like 100% in favor of one party. No, it was not 50-50, but rather some balanced. And it was quite unusual form for the ICAC, so it was some discussions with that. I did it as I was taught to do it in ICC Arbitration Academy, CR courses, etc. So it was more like international form, but in Ukrainian. And all of a sudden, after the parties received the award, you normally do not expect any reactions from the parties. I mean, when they receive the award, I mean, the reaction received by the institution. And in this particular situation, there were reaction of both parties. First, the claimant wrote, and I discovered this as arbitrator, then later from the secretariat. Then first the claimant sent a letter just thanking in details for the award. But it was okay, it was more or less winning party. And then all of a sudden respondent wrote to the ICAC asking for banking details to pay under the award, which is, I mean, it's absolutely unusual for Ukrainian respondent losing the case to be eager to pay anything promptly at all, but to ask that promptly from the institution, it was even more unusual. So the secretariat forwarded that request to the claimant. They somehow changed the details, and the respondent paid. And the claimant said the award has been complied with voluntarily by the respondent. And for me, it was very a rewarding experience. I have never had anything like that in my arbitrator's career after, but it was quite inspiring, I would say. Thank you.
When I was appointed as an arbitrator for the first time, I remember I called Olena to ask for an advice. And one of the most valuable advice that she gave me is that you write the award not for you, not for the institution, but for the losing party. And while drafting the award and procedural orders, I was always thinking, okay, so it's a very good story. And I wish everybody to have parties and respondents like this. Alexander, do you have a philosophical story to share or a fun story?
Yeah, I would join in firstly on the philosophical side, saying that we as lawyers have also, we are not simply citizens of Ukraine, we also have, due to our education, connection, status, and we can influence certain things. And the lawyers can talk on so many levels to different people in different jurisdictions. Lawyers in different jurisdictions, politicians in different jurisdictions, and this is also a task that must be carried out to convince everyone else that Ukraine should indeed receive the compensation, to actually set the matter straight, what actually happened. And this is something that you can do on any international fora, on conferences, just talking to your colleagues, to your friends, everywhere. And this is important because people in different countries, they also talk to each other. They also have influence in their own countries, in their governments. And this is the thing that we should collectively try to do because there is no other way to actually make the shift and put the things right, to actually so that everyone understand that what is the real situation in Ukraine from first hand, and to actually change something for the better, so that this situation will not repeat itself in the future. So I do believe that the audience that is listening now, us as well, also has many different connections and could make big or small influence in this matter. But on the fund side, maybe a slightly similar story to what Elena said, but not from arbitrator, but counsel perspective. I do remember we had the case once where we were respondent, and the claimant filed quite a big case. It was basically a construction case. There was a dispute between the employer and the contractor, and there was a dispute whether the contractor performed more works than it was paid, and they wanted additional money for the relevant works that they conducted. And when we prepared the statement of defense, we more or less rejected all the arguments, and we also said, in fact, we have a counterclaim. And we said, well, in this case, you also failed to do this and that and that and that. But we have not finally said exactly what was this about and what was the sum. After the claimant received the statement of defense, like a couple of days later, they said, okay, let's just sign a settlement and then basically release all our claims. We waive our claim against you, you waive your counterclaim against us, so let's just end it right now. So that was an interesting experience.
Okay, so we are almost 2 hours on the webinar, so I think it's time that we conclude. For some reason, when I was listening to the webinar, it reminded me of, you know, sort of annual evaluation that lawyers usually have. So this is 10-year evaluation of the Ukrainian Arbitration Association. I believe that it did well. It can develop further. It can work further. We have a lot to do, and I hope that arbitration will continue developing in Ukraine. The arbitration community will continue to develop and grow. And certainly, I hope, well, I'm sure that Ukraine will win. And that's yeah. So I would like to thank everyone, all panelists, for joining us on this webinar. I would like to thank everyone who join us on YouTube now, or who will be watching this webinar later. I invite everyone to join Ukrainian Arbitration Association who have not yet already joined. And as usually, I invite every member of the Ukrainian Arbitration Association to participate actively in its activities. We have plenty of them. So yeah, that's it. And thanks everyone again.
Thank you. Goodbye.
Thank you.
Thank you.
Thank you. Bye.
Bye.